Good morning, my name is Maxime Ebali and I work at the notary office Le Tulle Notaire based in Paris. Today I am going to talk about the different types of agreements which you may conclude when you want to buy a property in France. A person wishing to buy a real estate property in France must go through a conveyancing process which is a lot different than the process which is familiar to the US and the UK. Depending on whether a real estate agent was involved in the transaction, at some point, sooner or later, the process will involve a notaire. Each party may appoint its own notaire. In today's video, we will focus on the type of agreement it is possible to conclude in order to seal the deal. To begin with, in a nutshell, there are two main types of agreements which may be signed after a formal written offer to buy has been made from the buyer to the seller. The first option is a compromis de vente. It could be translated as a preliminary sale agreement. I will refer to this type of contract as compromis. It is a legally binding document and it may be drafted by a private party or it can be a notary deed which is drafted by the notaire. If you're not a French national or if the deal is complicated, it is highly recommended that you go through a notaire because you may not be accustomed to the French law intricacies and complexity. Due to the complexity of the transaction, this is a preferable option. A notary deed will ensure a higher degree of legal certainty, as the notaire is accustomed to drafting such documents and is likely aware of the legal issues which may arise. It should be noted that the compromis must contain all the details of the sale, as you cannot add anything to the contract after signing it. The second option is a promesse unilatérale de vente. It could be translated as a unilateral agreement to sell. I will refer to this type of contract as a promise in this video. In this kind of agreement, only the buyer is definitely bound by the agreement to sell the property to the buyer. The buyer, on the contrary, has an option. He or she may confirm the option and buy the property, or he or she may retract from the purchase. However, unless there is a good reason for doing so, or unless it was specifically provided for in the agreement, withdrawing from the contract will usually come at a price. The buyer will lose the deposit held in escrow, and which is usually about 10% of the total price of the property. The deposit is called in French indemnité d'immobilisation and comes for the compensation of the immobilization of the property. Furthermore, it should be stressed that under French law, the buyer may retract freely from the contract during a 10 days cooling off period. For numerous reasons, the agreement may fail on either side. Once the default has become clear, each party will pursue different goals. The advantages and drawbacks of each type of agreement will be reviewed in light of these specific goals. To have a default recognized from the buyer, for instance, the situation is different in the compromis as opposed to the situation where a unilateral promise has been signed. In the first situation, the compromis, because the compromis is a valid and binding agreement, legal action before the courts will be necessary in order to free the seller from its obligation to sell to the buyer. On the contrary, if a promise had been signed, the confirmation of the option by the buyer must occur within the agreed time frame in the agreement. If the buyer does not do so, it is not a contractual breach, but it is merely a possible outcome of the contract, and the seller will retain the deposit. The second situation is the sanction of the buyer in case of a default. In other words, how easy is it to impose a financial sanction on the buyer in case he does not go through? In the Compromis, a penalty clause is subject to be reviewed by the judge in case of a litigation. To have the agreement judicially enforced has drawbacks and disadvantages. First, the outcome is uncertain because the insolvency of the buyer, which is often the reason why the deal does not go through, may lead to a dead end from the seller. Furthermore, the property is frozen during the whole duration of the legal proceedings. During that time, the seller is unable to sell to another third-party buyer. On the contrary, if a promise has been concluded, the deposit held in escrow is fully owed by the buyer to the seller. The amount of the deposit is not subject to a judicial revision, that is to say, a possibility for the court to review the amount for the compensation. Indeed, the judge may not modify the quantum of the sanction. He may only decide to requalify the contract for a bilateral agreement to sell. To conclude, both agreements are a viable option. However, in most cases, notaire will draft promesse unilatérale de vente because of its advantages. The reason for this is that technically, the promesse has more advantages and is technically more predictable than the compromis de vente. Thank you for watching this video and feel free to stay connected on social media with Le Notaire in order to obtain more information about real estate in France.